So you're a dentist, eh? You're in the right place. This is the Canadian Dentist Podcast with Dr. Carlo Biasucci, where you'll get a truly Canadian approach to building a low-stress, highly profitable practice and live life on your terms. Learn more at theelitepractice.com.
All right. Hey, everyone. Welcome to this episode of the Canadian Dentist Podcast. I have joining me today, Mariana Brasic, who is the founding lawyer of MBC Legal, a name that surely you've heard in dentistry in Canada. 17 years now, if I understand that correctly. So it's, and now the the business has branched out into many areas, but primarily known for legal work, and this is across Canada. So this is a very timely conversation, as you'll see. Mariana, thanks for joining me.
Thank you very much, Carlo. It's a pleasure to be here.
So I just want to back up a little bit. This is going back to 2008. I was an associate and finally decided to take the jump to open a practice. And as all associates, I think, realize in that position that there are a million things that you didn't think about and don't know. And one of those things was contracts for employees. And so I did, did some digging at that time, 2008, going into 2009, when I opened and found Mariana and MBC, and actually had you guys prepare employment contracts for my team. So way back more than 10 years ago, when we first crossed paths, and I'm honored to be able to interview you today and ask some great questions of you. I think we've narrowed it down to the top 10 things that dentists would want to know, whether they're in some phase of opening or pending opening. So I think this is a great time for this discussion. So let's get into the first bit of our talk. Can we get into just some background? There's a lot of people looking at this situation, and there's a lot of misinformation going around. So I think if we could set the record straight on a few things, can you talk a bit about the doctrine of frustration at law and why it is important in this particular moment?
I think that's a really great place to start, Carlo, because I think it's helpful if the dentists watching this at home understand that the doctrine of frustration is a common law doctrine. And what that means is it's not necessary that anything be written into your agreements. It just operates by operation of law. So, and what the doctrine of frustration says is that where some unforeseeable event happens, as a result of which the contract between the parties is incapable of being performed, then both parties are absolved of their obligations under the agreement. So you can readily see how in the context of a global pandemic, a lot of people may be very eager to try to get out from the what have become very onerous obligations under their various agreements, arguing that they're incapable of being performed because of the doctrine of frustration. In the employment law context specifically, and because employment law is a subset of contract law, the doctrine of frustration applies to employment contracts as well. And remember that employment contracts don't have to be written. Like everyone at home watching this has employment agreements with their staff. Some of them are written, some of them are not written. Some of them are written well. From the work that we do at my firm, 95% of them are written very, very poorly and probably are not worth the paper that they're written on. Last time we checked the numbers. But whether or not you have written agreements or unwritten agreements, your staff have contracts. And so the doctrine of frustration may apply. And the $1 million question right now, I think, is, does the doctrine of frustration permit a dentist to terminate their employees is one big issue. And if so, then the normal obligations on termination don't apply. And the second question is, can the dentist lay off the employee because the contract has been frustrated and then bring them back when they're able to reopen? So those are the two big ways that frustration is relevant right now in the life of the typical dentist across the country. My own view is, and what we've been telling our clients, is not to put a lot of faith in the doctrine of frustration coming to the rescue, because the doctrine is really about allocating the risk of some unforeseen event. And Canadian courts have shown over and over and over again the very strong historical pattern of protecting what they see as very vulnerable employees. And if we sort of step back and say, well, the doctrine of frustration is about allocating the risk of some unforeseen event, I think it's reasonable to suggest that Canadian courts are not going to be terribly eager to allocate the risk of this unforeseen global pandemic on the shoulders of what they perceive to be relatively vulnerable employees. So what that means is, if you're not going to be able to rely on the doctrine of frustration to relieve you of a lot of obligations as an employer, if you lay off or if you terminate, then you really, really want to ensure you have strong contractual rights. And that's something we're probably going to keep hitting up against throughout our conversation today, because it's so relevant. It's a drum that I've been banging for 17 years, as you say, Carlo. Small employers like doctors, dentists need management flexibility. And the only way to get that in Canada is to fill an HR toolbox with all the management rights that a large corporation would have. And that means you need really strong enforceable agreements and policies. You need the right to change hours, change duties, change reporting relationships, possibly the location of work, all of those things. If you don't have a high quality enforceable agreement and policies that permit you to do that as an employer, then you don't have the right to do it, and it may trigger a constructive dismissal lawsuit.
Yeah, that makes sense. I think that the whole frustration angle is as you said, I wouldn't rely on it at all, right? I mean, I have seen through my time as an employer, and I know you've seen a lot more than I have, that the legislation is grossly favoring the employee, and there's very little likelihood that that's going to save anyone, but a solid contract would. So on the same thread, okay, now I'm looking at, I'm in Ontario, and a significant number of dentists in Canada are in Ontario. So we're looking at getting back to work now. What if I can't recall all of my staff? I mean, I can bring on, 5 of 10 or 8 of 10. Where does that put me in a position with the team that, that I necessarily can't bring on right away?
Yeah. That's a question that we are just getting all day, every day right now. Our inboxes are overwhelmed because everyone is in that situation. And, I don't think it helps that, some of the guidance coming out from regulatory bodies is pretty onerous. And it's hard to, in many cases, it's hard to see how a dentist can continue to maintain the same level of staff, if they have to leave an operatory empty for a certain amount of time, then what are they going to do with the staff, in between? And again, this sort of brings us back to the issue of having management flexibility. And, not just in the immediate short term, but I think for the foreseeable future, possibly for years, it's going to become extremely important for anyone in Canada who's a Canadian employer, but certainly, dentists, doctors, it's going to become really vital to their survival that they're able to ramp up and down their workforce according to what's happening in terms of the pandemic. I think many experts are predicting that it's going to sort of ebb and flow, and I don't know if we'll ever have a full lockdown again. I don't know. I don't have a crystal ball, but so to answer your question, the important thing is that the employer have the flexibility to bring back the staff that it needs, but not necessarily bring back everyone. And the more flexibility you have in your ideally well-written, and what I mean by well-written is not able to be successfully challenged by an employee side lawyer. So you want it to withstand that attack. So you want your agreements to be enforceable and to give you as much management flexibility to manage all the things you need to manage: hours of work, specific schedules, who reports to whom, what exact duties you may need. It may be the case that if you have fewer people in the office at any one time, people may need to do more multitasking than perhaps they've done in the past. And maybe cleaning instruments wasn't your job before, but now it needs to be, or whatever. So there just needs to be a lot more flexibility. And from my perspective, I think the difference between practices who are really going to emerge from this relatively unscathed and those who aren't is really the flexibility to manage the human resources.
Right.
So I'm such a nerd about employment law. I get very caught up with. I don't think I actually answered your question, and the answer really is, in an ideal world, you would have the contractual right not to bring back everyone if you didn't have need for them right away, and so that would mean you had strong rights with respect to layoff and scheduling and all of that. But if you don't, if your contracts are merely oral, that means your employees have common law rights, and the common law rights are much, much stronger than what you could get in a proper written agreement. Or if your contracts are written but they're not very good, or they're not enforceable, then the problem is if you lay off an employee, that may constitute a termination unless they consent. And I think in the first wave, a lot of employees were disposed to be fairly cooperative, although we don't know. I suspect we'll see a pretty considerable surge of litigation over this. So we don't know yet, and people have 2 years to sue. So if you don't have strong rights as an employer in terms of management flexibility, then a lot of things that you may otherwise do in the best interest of your practice will cause you problems on the employment law front, because a layoff is deemed a constructive dismissal without the employee's consent if you don't have the enforceable contractual right to lay off. And similarly, if there are some employees whom you just think you will never be able to bring back, well, then they're entitled to termination rights, and how much they're entitled to depends on what, as you know from your own experience, Carlo, if you have a valid, high quality contract, that can easily be the difference of 6 figures if you need to terminate someone, versus if they have common law rights.
Absolutely. Yeah. I mean, you're talking 10 weeks versus 10 months. It's a totally different world.
Exactly. Or sometimes we see it to be an even more extreme example, 8 weeks versus 2 years.
Yeah.
It's massive.
Yeah. I mean, that could be devastating for a small business.
Right.
So when I'm looking at recalling employees, do I have to pay attention to their tenure with the business, so their seniority?
Yeah, that's a good question. Generally speaking, seniority in recall rights is really only relevant in a unionized context, which, as you know, almost never happens in dental. Um, I would say, though, that there are a couple of considerations. So generally speaking, no is the short answer to your question. For most dental offices, that's not an issue. But I think there are two considerations that people watching this probably want to put their minds to. One is, again, if you don't have high quality enforceable agreements with good termination provisions, then it's the employees who have more seniority and who are older are going to be expensive to you to terminate. So, someone in her late 50s who's been with you for 25 years may cost you 2 years to terminate if you don't have a good agreement. Again, if you have a good agreement, 8 weeks should be the maximum that you should have to pay. So even though technically you don't have to sort of follow seniority unless you're in a unionized context, you want to recall that if you don't have good agreements, then those people are going to cost you more. And secondly, you want to be sure that in deciding whom to recall and whom not to recall, you don't inadvertently trigger a human rights complaint. And that would happen if the employee said, well, you brought back all the young ones, but you didn't call me back, or if the persons you don't call back are a member of any group that's protected under the Human Rights Code. So age, ethnicity, all the usual suspects. So you just want to put your mind to that. But otherwise, no, you don't really have to attend to seniority.
Okay. So you mentioned a few times constructive dismissal. How does that work? What is constructive dismissal? How is that different than, wrongful termination, or is it the same thing? Maybe we just kind of go down that road on some basic definitions for a moment.
Yeah, I think that's helpful for people to understand. So constructive dismissal is a subset of wrongful dismissal. And in wrongful dismissal, Carlo, you say to me, Mariana, you're fired, get out, or whatever. It's an express termination. In a constructive dismissal, the employee gets upset about something, or doesn't like something, or something's been changed. And if the court agrees that the employer did not have the right to make those changes, then it's a deemed termination. So in a constructive dismissal, you're not saying to the employee, you're fired. It's a deemed termination by operation of law. And constructive dismissal happens when typically there's some unilateral change to the terms of the employee's employment that is significant and adverse, to which the employee didn't consent. And so it's pretty broad. Like it could be anything. It could be a layoff if the employee didn't consent and you don't have a term in your agreement that allows you to lay off. It could be, a change to her schedule, or her hours, her duties. Any significant change without the employee's consent can be a constructive dismissal.
Okay, I want to just pick on one thing that you said there. You said if the person doesn't have a ability to lay them off. I mean, there's a lot of dentists who don't have contracts. So, and everybody just laid off all of their staff for a short time. So does that put those folks in a possible precarious situation?
I think so, absolutely. I think we're going to see an enormous amount of litigation over this, just enormous. And there's a lot of disagreement about, even among employment lawyers, about what aspects of the pandemic, if any, constitute frustration. And when there's a disagreement among lawyers, that means there's going to be a lot of litigation, because that's, where the law is clear, there tends not to be litigation because we all understand what the parameters are. I think, in this case, the issue is to deal with the Ontario case. On March 15th, I believe it was, the RCDSO strongly recommended that dental offices close to all but emergency services.
Right.
I personally don't think that that's sufficient to constitute frustration. So people who didn't have a contractual, employers who didn't have a contractual entitlement to lay staff off at that time, but did so, arguably will be open to constructive dismissal lawsuits. Now, I think in the first wave of the pandemic, most employees are probably disposed to be fairly cooperative, because I think we all felt like we don't know what's happening and it's crazy. And there's plus, the government has just been throwing money at it, which I think helped a lot of employees, help dull the pain. So, but arguably a week later, when the province mandated shutdowns, that may tip the scales. But one of the issues that I think about is whatever our collective sort of position was in terms of the foreseeability of a global pandemic back in January, February, March of 2020. Going forward, I don't think at any point in the next however many years, I don't think it'll be reasonable to say that a global pandemic is unforeseeable. So even if we got a free pass before, which I think we probably didn't, I think that I don't think that door is going to be open in the future. So again, I wouldn't counsel any employer in Canada to put a lot of faith in the doctrine of frustration to come to their rescue.
Hey, fellow dentists, did you know you can get a free copy of Dr. Biasucci's book, The Elite Practice Formula? Head over to CanadianDentistPodcast.com and click on Free Book. Now, back to our show.
So now is really the perfect time to make sure that your contracts are in place like this. As we get out of this shutdown, this is the time to make sure that you're set up legally, that you can lay off employees, that you have all these provisions in place, because if this kind of thing happens again, and I hope it never does, you're not going to be able to say, hey, we didn't see this coming, or, kind of go with that initial, as we said, it did take, kind of catch everyone. Well, it did catch everyone off guard. And, a lot of people are amenable to just kind of getting back to work. But, as this, and if I'm understanding you correctly, as this, if this should ever play out again, it's very unlikely that we're going to have an easy road through it like we may have. And you don't think we did, but, maybe we did, at least an easier pass with the first round. So hopefully this never happens again, but certainly take this time to make sure that your contracts are in place and things are tied up legally, right?
Yeah, I totally agree with you, Carlo. And I was interested to see that even within a couple of weeks of the lockdown, the practice protection package, what you were talking about, we did for you back in 2008. That's what we're most famous for, certainly in our legal division. That's been a pretty popular product among dentists and doctors since the early 2000s. But I was a bit surprised. Within a couple of weeks of the lockdown, we really surged in terms of how many doctors were contacting us to get that in place. And I think that speaks to their, having the good foresight to recognize that they will really need those management flexibility tools. probably not just in the short term, but in the long term. And of course, they're important as well when you go to sell the practice. In our brokerage division, we talk to clients all the time about that, because the buyer will definitely want to see those agreements in place. Buyers are increasingly surrounded by a team of advisors, their banker, their accountant, their corporate lawyer. Sometimes they have a separate employment lawyer. And those people all tell them that the price that they're going to pay for that practice is not just the amount that's set out in the purchase and sale agreement. It's that plus whatever the buyer is going to have to spend in the 18 to 36 months post-closing to clean up the seller's employment law problems.
Right.
And, all of that is just going to become that much more risky in a world in which we may be dealing with, recurring, frequent lockdowns or semi-lockdowns. I think this is a particularly good time to implement really good, high quality contracts and policies if you don't already have them. Also because I think the staff are relatively well disposed toward them. I mean, our experience has been that most employees sign the contracts that are presented to them anyway, like well over 99%. The last time we polled our clients, I think it was 99.5-ish%. I can't remember the final digit, but definitely 99 point something percent. So fewer than 1% of employees, even pre-COVID, nothing really significant happening in the world, fewer than 1% of employees don't sign. And if the process is done properly, you don't owe them anything. So, but most employees do sign. I think with the pandemic situation, we're going to see that number jump even closer to 100%, because I think employees recognize that, why those things are needed now.
Right. Absolutely. I've heard something interesting from our members on the lead practice side is, we're ready to open, but my hygienists or, some members of my staff don't feel safe to come back. Um, where does that put you as an employer? I mean, I've given them advice on how to make sure that they address those issues, from a practice management perspective, but what about employment law?
Yeah, so we call that work refusal, and we're seeing a lot of those questions as well, for sure. So under the occupational health and safety, there's occupational health and safety legislation across all the provinces, and generally speaking, it imposes an obligation on the employer to maintain a workplace that's safe. And there's a procedure in place for what happens if an employee considers the workplace unsafe. In this context, I would say, if the employee is raising some issue with respect to whether they're safe because of COVID, I would look at your IPAC program. Certainly, you're going to want to update that program. And at our firm, our director of health and safety has been working feverishly since mid-March to integrate, all of the new post-COVID requirements into our program. But if that happens to you and an employee is saying to you they don't feel safe, you want to look at your IPAC program, sit the employee down and say, this is what we're doing to address these concerns. And, hopefully that will allay the employee's concerns. But if not, the next step is to contact the Ministry of Labor, and they will have an officer look into the situation to determine whether it is indeed unsafe or not. I think it's reasonable to expect they're going to be swamped for the next many months. And in our preliminary conversations with the ministry, they seem to be taking the view that it's not enough just for an employee to say, well, I feel unsafe because COVID. Because that, your workplace, that would be like saying, well, I feel unsafe to go outside or whatever. Like, that's not reasonable enough of a concern. There needs to be, at least preliminarily, again, and they haven't committed this in writing or anything, but in our preliminary discussions, they're suggesting that there needs to be some specific concern that's more than just, I'm afraid of getting COVID.
Sure. I mean, as an employer, I don't think I'd be overly excited about, calling the ministry to come and have a look in my office and, do an inspection and determine that it's safe. So let's say the employee says, okay, well, I just don't feel like it's safe. And the employer says, okay, well, then don't come back. Um, you know, I'm assuming you still have to maintain their employment or maintain their position, but you could move on, you could restructure, you could do, you could basically get the business rolling unless it's your entire hygiene department, I guess. But if it's just one employee, I'm assuming that you can still get back to operation and then you just have to maintain their position, right?
Yeah, I think the issue would probably need to be resolved sooner than later. But I agree with you in the sense that it's not like you have to stop everything, assuming you have other staff who are willing to come in, and I think most people will be willing to.
So the bar is basically set at if you have met all of the regulations and guidelines in place, then the workplace is safe. It's just now a matter of opinion, which is where you suggested the ministry actually make a ruling.
Yeah, you do need to, if the employee continues to take the position that she feels unsafe, you do need to bring in the Ministry of Labor. There isn't really a way around that.
And this is a very ugly situation for potential termination, which you just
Mhm.
you wouldn't even want to go there at this point.
Oh, absolutely not. You would incur, it would be like a reprisal situation, sort of like a whistleblowing problem. You definitely would not want to be seen to be doing that.
Yeah. So
Yeah.
there's no real easy way around that except to do everything that you can and then, push the burden of proof over to say, okay, we have done everything we can, and then try to meet that employee somewhere to say, okay, we agree to move forward. Because if we can't resolve that legally, it's a very ugly spot for an employer.
Yeah, yeah. I, I don't want to exceed the scope of my expertise. I'm an employment lawyer. I'm not an infectious disease expert. But I really feel that all of us as citizens need to sit down and do some very hard thinking, because no one is, no institution is doing it. My concern is that governments, regulatory bodies, journalists, media, a lot of institutions that we ought to be able to rely upon to, canvass the research, make rational, evidence-based decisions. I don't feel that that's really being done right now. And I've tried hard as an admitted non-scientist to really follow what the data and the science tells us. And, according to the science, as of May 1st, in Canada, if you were under 65, your chances of dying with COVID were 6 in a million.
Yep.
That's the same risk you have of death if you drive to work 21 kilometers.
Yep.
My concern is, governments have an interest in, among political scientists, it's well known that it's great to be a leader during a crisis because you tend to get way more popularity than you ordinarily would. You get to throw billions of dollars at a problem, and people like you. And the media's interest, unfortunately, isn't a perfect fit with just disseminating good, rational arguments and facts and data. They have a strong interest in sort of writing clickbait articles, and what sells. Fear sells. So I feel if we don't, as citizens, as individual business owners, and even workers, just citizens, if we don't do the research and try to inform ourselves and share that information and put pressure on our governments to make good, reasonable decisions, we're going to end up in a very, very bad place. And I think we're heading there quickly. So anyway, as I say, I'm not trying to exceed the scope of my expertise. I am an employment lawyer, but I think we all, no matter what we do, whether we're a hygienist or a dentist or a nurse or a restaurant owner, should really try hard to find the actual scientific evidence, and put pressure on our governments and our regulatory bodies to make decisions that actually accord with those.
I completely agree with that. So I'll leave it at that, because that's a conversation that could go on for hours, but you're absolutely spot on. Where I do want to go with that is, with respect to the whole IPAC and infection control scenario, the college in Ontario has put out some guidelines. What are the implications for building out your IPAC, or changes to it now? And then I want to get into, as an employee, or as an employer, sorry, what is my risk if, because I'm seeing this now, I'm seeing a lot of organizations come out and say, here's some sort of wording you should have with your staff, such that if someone actually gets COVID and they work for you, can they claim they got it in your business and then come at you legally for it? And that kind of takes us into insurances, WSIB as an option. Can we kind of go down that road?
Sure. We've seen, and a number of clients brought to our attention that they'd got a copy of some document like that was sort of making the rounds around the internet. And I think a lot of them are coming from American firms. We don't really see the value in having your employees sign a waiver. First of all, I would be very surprised if that was legally effective to absolve you of liability in any event. So I don't really see the value in doing it, and I think it just raises to my mind, a kind of unpleasant interaction with your employees for a legally ineffectual result. So I wouldn't recommend it. I do think insurance coverage is important at any time to look at. And having had a flood recently in my home, you're very glad if you look at your insurance coverage and it is what you would have hoped it was. So by all means, look at your insurance coverage, determine what coverage do you have if an employee gets ill. I think for most people watching this, that's probably CDSPI, but whoever your insurance company is, look into what your coverage is. Some people have asked us about WSIB, and historically, I haven't been a big fan of WSIB for a lot of reasons. I think that the coverage is not really what it's insuring the wrong risk. WSIB, you as employer are paying premiums to cover the employee's lost wages, but that's not the same as the risk you're really concerned about. The risk you're concerned about is your legal liability, which is a different issue. And so that plays out in a number of contexts. For one thing, I think in a situation where the employee wants to continue to maintain a relationship with you, she's very unlikely to sue you. I mean, employees are perfectly willing to sue once they're done with you. But if they want to continue to work there, like in the context of, an injury at work or something, I think they're pretty unlikely to sue. Whereas if you have WSIB in place, I think most employees wouldn't think twice about making a WSIB claim. And so the effect of that is that, your premiums go up. So it's still a cost to you. And the flip side of it is, just because they got injured doesn't necessarily mean you were negligent or otherwise liable at law. So again, it's kind of a mismatch. Plus, we know from actuarial evidence that the more disability insurance employees have, the more absent they are from work. And so as an employer, as a business person, you're paying money for an economically irrational result. You are paying premiums to see your absenteeism go up, which to my mind doesn't make sense. So for all of those reasons, for almost 20 years now, I've been saying to clients that I'm not a fan of WSIB for anyone who isn't statutorily required to register, and dentists are not, lawyers are not. So I think if you're not required, I've always taken the position that I don't see the value in it. So far, nothing about COVID has made me change my mind. I suppose time will tell if something comes up. But everyone needs to assess their own risk level and their own comfort level. And certainly I would want to speak to CDSPI or my insurance company and make sure that I was satisfied with whatever coverage I do have before I walked away from WSIB.
Makes sense. What are your thoughts on legal expense insurance then? I know this isn't an insurance conversation, but it's just kind of picking up from that. It's something that I have used multiple times, so I'm curious what you think.
Well, I'd be curious what your experience has been.
It's been basically coming around and dealing with employment issues. So picking up the tab for some of the things that we talked about.
Right. So my experience has been that I haven't seen great products out there. And when I have a client who has the insurance, I ask them, what's your experience been? And on the whole, now I don't know if this is a statistically reliable sample size or whatever, but on the whole, the comments are generally not good because it tends to be a very limited amount of coverage. You use up the funds quickly. But I imagine, a lot depends on the precise circumstances and obviously the precise product. So it's hard to say. But to date, I haven't seen really great products out there.
Okay, fair enough. One last question for you. Given the whole scope of COVID and the intense overreaching lockdown, destruction of economy, and so on, what do you think this is going to look like for sales practice values, as that is something that you guys do get into?
Mm-hmm. Yeah. And, if you don't mind, I'd like to qualify my earlier comments because I wouldn't want to be seen to be glib about the pandemic. I know that, many thousands of people have died. My parents are in their 80s. I love them dearly. My mom was in the hospital during the COVID crisis. So I know that it's serious and I'm not in any way trying to minimize it. I just think that for the vulnerable segments of our population, we need to do more than we're doing because what we did do did not protect them.
Right.
Meanwhile, we're going through these, I think, unwarranted measures for the low risk segments of our population and thereby depriving ourselves of some very much needed herd immunity. Anyway, I just want to say that I'm I'm not at all trying to minimize the risk. I think it's very serious. But having said all that, and to answer your question, the advice that we're giving to dentists is, keep calm and carry on. We think your values are safe. A huge consideration is it's not as if your patients are going elsewhere. It's not lost revenue, it's just deferred revenue. They will come back, and arguably there's pent-up demand, so you're going to see even an increase. At MBC Brokerage, we are working with the major Schedule I lenders to adjust for the COVID anomaly in our appraisals. We take that very seriously because we have an excellent relationship with the Schedule I lenders. They will lend 100% based on our appraisals. So, the appraisal process and the integrity of it is obviously very, very important. But I'm personally very interested to see what's going to happen in the market. I did a webinar recently in which we polled the attendees, and fully 24% of them said that the pandemic had sped up the time at which they intended to exit practice ownership. So I think it's going to do some very interesting things in the market. But a dental practice is still an excellent investment, and I think it will be for a long time to come.
Excellent. Mariana, thank you. Great information. How do people listening to this show reach out to you, find you guys, get more information? Kind of what's the next step and where would they go?
They can find us online at mbclegal.ca for the website, for the legal division, and for the brokerage division, mbcbrokerage.ca, or give us a call at 905-825-2268.
Fantastic. All right. Well, I thank you for your time. Great information. I think anything beyond this would be individually specific. So reach out to MBC if you have further questions, guys. Thank you, Mariana, for joining me.
Thank you so much, Carlo. It was great to connect with you again.
Awesome. All right. Thank you. Have a great day. We'll talk soon.
Okay. Bye-bye.
All right.
Thank you for listening to this episode of the Canadian Dentist Podcast. If you want to know how Dr. Biasucci tripled his practice in 3 years and cut his work week in half, request your free information kit at theelitepractice.com.